Hello and welcome to another edition of ChrisChat. My name is Christopher Diorio. I am an attorney and civil rights and constitutional law professor here in Massachusetts, and I do these ChrisChats as brief lectures, talks about certain areas of the law, usually involving civil rights or constitutional law. Wait a little bit for folks to populate in. Thank you for popping in for a ChrisChat. Today, what I want to get into, I've gone through and posted these. There is a YouTube channel now for ChrisChats. You can go back and look at all of these on YouTube. Just look up ChrisChat and they're there. The first 9 are all there for you to review. But what I want to talk about today is something sort of more broad. Based on current events, there was some recent discussions with the Sunday morning talk shows, etc., with members of the current White House not necessarily having or exhibiting a decent understanding, shall we say, of what the different branches of the government are entitled to do. And other people, and I read a poll recently that 48% of folks believe that the president should have supreme power, but more of them actually thought that the president did have supreme power. Basically what I'm getting at is that there seems to be a general lack of knowledge about what it is that the Constitution says, but more importantly, what the Constitution says about the individual powers of the branches of our government, the legislative, the executive, and the judicial branch of the government as addressed in the Constitution. So, in as brief a fashion as I possibly can, I want to go back and take you back to what I would think for many of us, hopefully many of us, should have been a civics or government primer as to what it is that the Constitution says and does, and what it permits and what it doesn't, as far as our 3 branches of government are concerned. First, I have to tell you, right off the bat, if you look at the other ChrisChats, I try to be a little bit more subdued in an effort to teach, but I'm going to not necessarily be able to restrain myself here, because I got to tell you, I love the Constitution. I have ever since I was a kid, watching Schoolhouse Rock and listening to them sing "We the People" and listening to "I'm Just a Bill." I have always loved the Constitution. It takes me back to the great foundational documents of history, and this being one of them, in line with the Magna Carta and things of that nature. We are sitting here with one of the shortest constitutions in the history of the world, and yet one of the longest lasting constitutions in the history of the world. And not understanding what it says is, I think, an affront to basic democracy. I was told a story years ago as a young poli-sci major by one of the 2 men that I still today refer to as Yoda. They were the ones who set me on the path to being the attorney and educator that I am and want to be. The professor's name was Joseph Kabilka. He is a professor at Southern Methodist University, and he was an icon for me in political science. And he told me the story of young Hugo Black, former Justice of the United States Supreme Court, who never left his home without a copy of the Constitution of the United States in his breast pocket of his jacket. Never left home without it. Before he became a judge, before he became a justice, just as a young lawyer, this followed him everywhere. And so, that day, I went out and purchased my own, and here it is. This is, you can tell how old it is. I bought it for $1 at the school bookstore at the Southern Methodist University, and I've carried it ever since. You can also tell how old it is because when you look at the cover, it's up to 1987, and it only goes up to Amendment 26. It completely leaves out the 27th Amendment. I am not getting rid of this. I know what the 27th Amendment says, but this is always with me, and it should be with all of you. There's no excuse for not having it with you, but it is a tremendous formational document, beautiful in its lyric language, and it starts right off the bat. Every great musical theater show, hits you right at the outset with something great. And we get hit in the Constitution with the preamble, and it is magic. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty for ourselves and our posterity, do ordain and establish this Constitution of the United States of America. It rolls off the tongue. It is tremendous. It's beautiful. It's music to a constitutional nerd's ears. But most importantly in that are two sections. One, right at the beginning, it's a two-letter word, we. We, the people. Not small groups of people. We, the people, formed this government. We is the most important word you will find in the Constitution. And it's two letters, we. And next, the beauty of this and why the Constitution is so amazing and breathes it like a living thing is the language at the end, for ourselves and our posterity. Do ordain and establish this Constitution. They weren't thinking just about themselves right there. They were thinking about forming the future. And they allowed themselves in drafting and crafting this document the way they did to make it so that it grows, so that it lives and breathes and can fail and succeed and can be added to. It's for my money, the greatest single formational document drafted by mankind. This right here, and it's ours. And we have to understand it. We have to know better as to what it does. After that preamble, that beautiful intro that brings you into the document, now you have to start looking at the foundation. What does this do? What are we making with this Constitution? What we're doing first in Article 1 is creating a legislative power. We are putting legislative power, and it is vested in a Congress. And the Congress shall be made up of two houses, the Senate and the House of Representatives. That's Article 1. Article 1 is talking all about legislative powers, what the Congress can do and what they can't. First, it says what the different qualifications are. Congresspeople, members of the House of Representatives must be 25 years old. They must be 7 years a citizen of the United States. They don't have to be natural born. They can be born in other countries, move here, and still be congresspeople if they are 7 years a citizen of the United States and over the age of 25. They have a 2-year term, and the number of congresspeople is dictated by population. See, what we have when we created the Constitution is a conflict. As always, when greater heads are put together in one place, there was a conflict as to what type of legislative body we should have. And we have what's called a bicameral legislature, two houses, because of a compromise, the Connecticut Compromise, that allowed for one house to be representative of population, that each state has a number of representatives based on their population. So if there's a larger state, they get more people to send to Congress. Smaller states get very little. It's based on population. So that's what the House of Representatives is. The House of Representatives initially, and this is something that you'll see in Article 1 if you want to take a look at it, and I encourage you to, when they were determining initially what the population should be for calculating representation in the House of Representatives, the language in there refers to treating free people as one person, and then those who are indentured servants or slaves as 3/5 of a person. Slaves were considered 3/5 of a person for purposes of calculation of population. That clause has never been invalidated. Technically, it's never been erased from the Constitution. It still exists. It's been modified by the 13th, 14th, and 15th Amendments, but the clause still exists. It sits there in the Constitution as part of our foundational documents where we treated slaves as less than a human, or at least 60% of one. Inside all of those qualifications in Section 2 of Article 1, the House of Representatives has the sole power of impeachment. It's a great authority that they have, but it's vested in them, the sole power of impeachment. They start the process. After that, we have the Senate and the Senate qualifications. You've got to be 30 years old in order to be a senator or more. You have to be a citizen for 9 years. Again, you don't have to be natural born to be a senator or a representative. The Senate is the house that dealt with small states. We wanted to allow small states to have the same voice as big states. That was the trade-off with the Connecticut Compromise. So the Senate, regardless of how big or small you are as a state, you each get 2 senators. Rhode Island has 2 senators. They have 1 congressperson. Wyoming has 2 senators. They have 1 congressperson. California has 47 representatives to Congress, 2 senators. Regardless of your size, big or small, you get the same voice and 1 vote inside the House, inside the Senate when it comes to your representation there. It provides for balance between large states and small states. Every 2 years, they cycle through. So there's 100 senators, 50 states, 100 senators. And they cycle through. 33 are up for re-election every 2 years, along with the Congress. If there are vacancies, the governor gets to fill that seat. The governor of that state gets to appoint a senator until the next election cycle comes around. The vice president of the United States is considered the president of the Senate. They don't have a vote, but as we saw recently with the confirmation of Betsy DeVos to head up the Department of Education, when you have a tie in the Senate, 50-50 vote or whatever the tie is, the vice president does have a vote, and the vice president is the tie-breaking vote. And that's right there in Section 3 of Article 1. While the House of Representatives has the sole power to start an impeachment, it is in the Senate where impeachments are actually tried. So once they vote to impeach somebody in the House, they send it to the Senate, and that's where the impeachment trial actually takes place. And in order for a president to be, or any a justice or anybody else, to be impeached, you have to try it in the Senate, and there has to be a 2/3 vote of the Senate to impeach somebody. The Chief Justice of the Supreme Court sits as the judge in the Senate during that impeachment trial. That's what they have initially in Section 2 and Section 3. Section 5 of Article 1 says that each House creates their own rules of conduct. They can compel members to attend. They can also expel their own members. If a particular member of Congress has brought disrepute upon the House or upon the Senate, they can vote to exile them, in essence, to expel them from either the Senate or the House. They can do so with a 2/3 vote of that body. So just because you got elected by the people, if you have committed some high crime or misdemeanor and you can't be removed and they want to get you out before the next election cycle, they can vote you out inside the body itself. They control their own rules. Another interesting part of Article 1, Section 6, when these folks are on the job, when they are on the floor of the Senate or on the floor of the House, they are immune from being charged with crimes while they're in session. They're also immune if they are driving to or from the session, or however they're getting to and from. This is congressional immunity, and they are shielded from being prosecuted for crimes. How do they start things? The legislative power, as I said, is apportioned to the Congress in Article 1. What do? Well, all bills that deal with revenue, the budget, must start in the House of Representatives. And they go back and forth between the House and the Senate, and then they can go on and get in front of the president. And once they put a bill in front of the president that both houses have agreed to, after committee, etc., and amendments, they put it on the president's desk. And the president can either approve it by signing it, or in terms of the Constitution, can return it to them with his or her objections. That's the veto. If the president doesn't sign off on it, it's not a law. But if both houses, both the House of Representatives and the Senate, have 2/3 of their members that vote for this law, it overrides the veto. So the override provision that you'll hear about is in Article 1, Section 7 of the Constitution. Then here comes the meat. This is where, if you know these things about what the legislature can do, the legislative powers granted to the Congress are enumerated in Article 1, Section 8 of the Constitution. And there are a number of them. There are a lot of them. And I'm going to go through them briefly and just highlight the ones that need to be highlighted. The Congress, the legislator, has the power to impose and collect taxes. That's their job. They have the power to borrow money on the credit of the United States. They are in charge of incurring debt. If they're going to incur national debt, that's where it comes from. The Congress is in charge of interstate commerce, either within the states themselves or with foreign bodies. They are permitted to regulate commerce. They are permitted to define what the rules are regarding immigration and naturalization. They're the ones who create what our qualifications are for entry into the country. So when we get to the discussion of the presidency and how they believe that they have authority over this, it's not with the executive. It's here in Article 1, Section 8. The Congress creates the rules as far as immigration and naturalization. They create post offices. They are the ones responsible for creating roads. One thing very interesting, and especially with the idea that they're trying to eliminate the National Endowment for the Arts, right there is tucked in as a requirement, a job of the United States Congress is to Article 1, Section 8, subsection 8. They are required to promote the progress of science and useful arts. So they're the ones that create and support arts. It's right there. They're supposed to do the job. Whether they do or not, well, remains to be seen. Congress has the power, and the only body that has the power to declare war. Only Congress can do it. While we'll see in Article 2, the president has commander-in-chief powers. The commander-in-chief cannot commit us to war and declare it. Only Congress can do it. Article 1, Section 8, subsection 11. Subsection 12, they can raise armies. But if they raise armies, their appropriations only last for 2 years. The military has to keep coming back to them and asking them for money. They have the power to raise a navy under subsection 13. Subsection 15, they have the power to call a militia to suppress insurrections. So we're talking those folks who talk about, the Second Amendment and the well-regulated militia. They've talked about the well-regulated militia. It's right here, and who has the power to do it. Very importantly, here in Article 1, Section 8, subsection 18, Congress has, from the Constitution, the authority to make all laws, quote, necessary and proper, end quote, to carry out the above powers. So they have all of this authority and all these things that they have to do, but they now also have the authority to make whatever laws they deem necessary to make all of this happen. So they can create an immigration and naturalization service. They can create laws that address bankruptcy and copyright and all to address the arts. They can impose and create the IRS and draft the Internal Revenue Code. That's power that's given to them inside the Constitution. That's all of the enumerated powers of the Congress, and they're there in Article 1, Section 8. Go see it. One other essential part of Article 1 is that there's language in Section 9 that says no person holding any office of profit or trust under them shall, without consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. You have heard the word, the emoluments clause. This is it. What this says, however, addresses the legislature. It talks about no person holding any office, but it's inside Article 1. So the conflict here that remains to be determined is, does this actually apply to the president? Presidents will say no. The legislature may say otherwise. We, the people, as I talked about at the beginning, may say otherwise. That's Article 1. That's the legislature. You move on now to Article 2. So the legislature in Article 1 is empowered with creating the laws, necessary and proper, subsection 18. They're the ones who create the laws in these particular areas. Article 1 is a long article. There are 10 separate sections and a number of subsections underneath. Article 2 deals with the executive branch. It creates the presidency. And it is an extremely small part of the Constitution. Only a few sections. it pales in comparison to what we wanted to do with the legislature. Why is it that the Article 2 powers are so small? Because we had just fought a war against an imperial monarchy. We did not want another monarchy here on our shores. The line that they would use back then in debates as to whether they were going to separate was whether we wanted to trade one monarch 3,000 miles away for 3,000 monarchs 1 mile away. We didn't want to impose a monarchy here in this country. So they limited severely the power of the president. Article 2 has 4 basic sections to it. The first and the last deal with qualification and impeachment. So there's really not a whole lot of meat to the presidential bone. Article 2, Section 1 deals with qualifications. The president and the vice president serve a 4-year term, and it discusses the formation of the Electoral College. Electors based on the number of congressional members. Most importantly, here in Article 2, Section 1, the president is the only officer of the government that is required to be a natural-born citizen. That means born in the United States. The president must be 35 years old and at least has been a resident of the country for 14 years. So born in the United States but a resident of the country for 14 years. Well, they could be born here, move to another country for 30 years, come back, and then live here for 14 years and then run for president. The key there is at least 14 years in the country and a natural-born citizen to start. And that's really the only qualification on a president. There's nothing else that says what they have to do or whatever their experience is. Be 35, be born here, and have lived here for 14 years or more. That's it. Now you get deeper into Article 2, Section 1, and you go into how do you fix if the president is removed or if they die or if they resign. It falls to the vice president. But then it says further that Congress has the power to create the succession rules, and they did later on, as we will see in amendments to the Constitution, created the succession of powers. And again, in Article 2, Section 1, it refers once again to emoluments. But here, in Article 2, Section 1, it does not refer to emoluments from other countries or foreign kings or princes. It says that the president shall be paid a salary and shall not receive any other emolument from the United States or any of the states. So you can't slip the president a 50 from Rhode Island and say, keep it fair. You can't do that. But there's nothing there that says that foreign countries can't do it. So now there's an emoluments issue because they mention emoluments initially in Article 1, and then they mention it here again in the executive side. Which is which? What really controls? Article 2, Section 2 deals with what the executive powers are. People spend millions upon millions of dollars to become the President of the United States and to sit in the chair that belongs to the leader of the free world. And the powers of the president are weak. In a sense, the president is the commander-in-chief of the military and is also the commander of the militia. Again, they talked about in Article 1 about the ability to form the militia. The president is the commander of the militia. Article 2, Section 2 also deals with the president requesting opinions of officers of the executive department to report back to him. So this is one of the things that leads into the formation of the cabinet, which is not mentioned in the Constitution. There is no cabinet in the Constitution at all. It's a formation of the government that occurs afterwards related to this. So that's the first and perhaps largest power, is the commander-in-chief of the largest army in the world, the most powerful army in the world. But Section 2, subsection 2, deals with the powers of the president to nominate ambassadors and justices of the Supreme Court, other officers of the United States, cabinet members being considered that after the fact. But now all of those powers are limited. They're limited by the advice and consent of the Senate. Anyone that the president puts forward to hold these jobs, any court positions, to fill the lower court positions, to fill justices of the Supreme Court, ambassadors, etc., all of them have to go through the Senate. So you have the power to name these people, but you don't have the power to actually put them in the job. The job actually comes from the Senate. This power is limited. So the only power that's really not limited in the Constitution is that commander-in-chief power. This, the power to appoint justices, which frankly is a more broad-reaching power than any executive, the greatest, I think, power that a president has, is to affect the future going forward for potentially decades by selecting justices to the court. We talked about this in a previous ChrisChat. The president can also do what's called a recess appointment. And there was a lot of talk about this during the end period of the Obama administration, attempting to get Justice Merrick Garland appointed to the court. And there was discussion of the possibility of a recess appointment when Congress is not in session, when the Senate is not in session to address appointments. The president can appoint someone and they get the job until the legislature comes back around and discusses the matters further. But that's it. In terms of powers of the president, they have commander-in-chief powers. They have the power to have their administration talk back to them to get opinions. They can reprieve or pardon or commute sentences, which is a tremendous power, but they cannot pardon someone who's been impeached. If you remember your history, Richard Nixon was not impeached for his conduct during the Watergate. He started an impeachment process but wasn't actually impeached, which allowed President Ford to give him the pardon that he did once he took office. If President Nixon had actually been impeached, he could not have been pardoned. The other requirement of Article 2, in terms of the powers of the president, is to provide a State of the Union to the Congress. He shall, from time to time, speak to the Congress and give them a State of the Union. Also inside this section, Article 2, Section 3, is a requirement that the president shall take care that the laws be faithfully executed. So any laws that Congress proposes and that are in fact laws, the president's job through his administration is to faithfully execute those laws. It's a constitutional mandate. You have to do it. Article 2, Section 4 deals with impeachment. So all of the power here is very limited. The president has military authority. They have authority over, pardons and reprieves. They can nominate people but can't actually appoint them to anything. And they have to give a State of the Union. That's it. Where's the power here? It's been assumed. The president can, in the State of the Union, suggest certain things, can suggest a course of conduct to the legislature, but the president can't write a law. Can't do it. It's not his job. He's not empowered to do it. Executive orders aren't even come under the faithfully executed portion of the Constitution. If you ask anybody, that they do that, and the requirement of opinions of officers, they're allowed to do these orders back and forth. But that's how that works. The power of the presidency is extremely limited, and yet it is the most powerful position we have in this country, allegedly. So that's Article 2. So the legislature, Article 1, the legislature, the Congress, makes laws. 2, the president is required to execute the laws. He shall take care that the laws be faithfully executed. That's the president's job. Now what happens? You have Article 3. Article 3 creates the judicial branch. And this is where a lot of the smoke and mirrors has occurred related to, we have a judicial supremacy and the judiciary is king in this country and taking it's not. Article 3 is another very short article. There are only 3 sections to Article 3, creating the judicial branch. Article 3, Section 1 says the judicial power shall vest in one Supreme Court and such other courts created by Congress. So the only court that is specifically mentioned to be created and has to be created by the Constitution is the Supreme Court. That's it. All of the other courts exist. Federal district courts, federal admiralty courts, federal appeals courts, the various circuit courts, all of those exist only because the Congress created them. That's it. All of the power there vests in Congress, and Congress can limit their jurisdiction. The only thing Congress cannot do is limit the jurisdiction of the United States Supreme Court. It has constitutional breadth and authority because it's the only one named in Section 1 of Article 3. While the Congress people have 2-year terms and senators have 6-year terms and the president has a 4-year term. There is no term limit on federal judges, which is why when you get named to a court, that's why it's so powerful from a president to put someone on the bench that can sit there long after the president is gone to influence what the law is and what it says. They are allowed to hold their officers during good behavior. That's it. If they commit crimes or something of that nature, they can be impeached. Otherwise, they either resign or they go out of the courthouse feet first. That's it. All of the other courts, strictly limited to what the Congress creates. So what exactly is their power? Article 3, Section 2 says that the judicial power extends to all cases arising under this Constitution, the laws of the United States, and then it goes further into different jurisdictional discussions. Then, Article 3, Section 3 says that, well, it's a definition of treason is all. Because the Supreme Court has original jurisdiction, which means they get to see it first. Nobody else gets it. They have original jurisdiction over crime, over treason charges, so they have to define what it is. Treason is only in levying war against the United States or in adhering to the enemies of the United States, giving them aid and comfort. For those of you who are looking for grounds to impeach the current administration, take a look at Article 3, Section 3 and see if that answers any of your questions as to how it can start. But again, recall, it has to start in the House of Representatives and gets tried in the Senate. That's directly out of Article 1. So now, that's it. That's the only power described in the judicial branch. We have power that extends to all cases arising under this Constitution. Where does it say? If you have a copy, if you have it handy, or if you have it online or on your phone, as I suggested last week, everybody should have a copy of the Constitution on their phone. Go look at the Constitution right now and tell me where it says that the United States Supreme Court and lower federal courts have the power to say what the Constitution means. Go ahead, I'll wait. I'm not going to wait. It doesn't exist. It doesn't exist. It's not in this book. It's not in the Constitution. Judicial review does not exist in the Constitution. It only exists because the United States Supreme Court took it for themselves as a necessity, as part of their Article 3, Section 2 powers. The power extends to all cases arising under this Constitution and the laws of the United States. If those of you who remember this or those of you who don't, judicial review was created in a Supreme Court case, Marbury versus Madison, in 1803, when John Adams, in all of his peckish glory, decided that after Thomas Jefferson beat him for the presidency in the election in 1800, decided that he wanted, during the transition period, to put as many judges as he possibly could on the federal bench and to appoint as many administrators as he could to strengthen the Federalist hold on the government. Back then, once you went through a friendly Congress, which Adams had prior to Jefferson's election, once it went through the Congress, once it went through the Senate and all of these appointments had been heard, it required that there be a document, a commission, that had to be signed and stamped and sealed and taken from the Secretary of State to the individual who had been appointed to the court. And at that point, that was their, basically, here's your job offer and sign the contract and go. Prior to Jefferson's inauguration, over 100 of these went out. 4 got missed. One of them was a gentleman by the name of William Marbury. Jefferson told the Secretary of State, a guy by the name of James Madison, by the way, he wrote this thing we're talking about today, told James Madison, the Secretary of State, do not issue the remaining commissions. Marbury sued James Madison and said, you are required to do so by law. Your job requires it. It's called a mandamus. A mandamus petition says you have a job to do and I'm ordering you to do it. The case went to the United States Supreme Court because it dealt with an officer of the United States government. And in the case of Marbury versus Madison, Chief Justice John Marshall, who wrote the opinion in Marbury, said that we have the authority here to address these issues, and we're going to hear it, and ultimately denied Marbury's commission. More importantly, though, as opposed to the political intrigue of denying the commission, Marshall said, "It is emphatically the province and duty of the judicial department to say what the law is." In that small phrase, and those around it, John Marshall created judicial review, saying that if we are empowered to act on and to discuss cases arising under this Constitution, we must be empowered to interpret what in fact the law says. And that's where judicial review comes from. It is not constitutionally guaranteed. There is no specific rule like giving the president commander-in-chief powers. There's nothing there that says they have this authority. They took it. They took it, and it's never been questioned. Certainly not successfully. So that's where the judicial review comes from. Just briefly through the rest of the Constitution, Article 4 refers to full faith and credit, that if something happens in one state, it has to be given full faith and credit in another. If I sign a contract in Massachusetts and bring it to New York, it has to be adhered to. Every citizen has the same privileges and immunities as every other citizen in the state, in the country, excuse me. Article 5 deals specifically with amending the Constitution. How do we do a constitutional amendment? I talked about this a while back, but I'll repeat it. It requires a 2/3 vote of both houses to approve the amendment. So it requires 67 in the Senate, and 231, I believe, is the 2/3 line. No, that's the majority line. Excuse me. I'm not going to do the math for you. But it requires a 2/3 majority in both houses. And then once it's passed through both houses, it has to go to all of the individual states and be ratified by 3/4 of all of the individual states. And at that point, it officially amends the Constitution. It is a long and arduous process. It's only happened 27 times in the history of the Constitution, and the first 10 occurred 2 years after the Constitution was ratified. So we've had 17 amendments over the course of the last 220-odd years. It's a rare thing that gets done. And the reason why is because the Constitution is so great, because it breathes so well, because it's flexible. Most importantly, and this deals with what we've heard recently from this administration regarding, well, the court shouldn't have to do this, and the executive saying you don't have authority over this, and the court's saying yes we do, and the back and forth between the parties. Article 6 is very important. Article 6 says that this Constitution and the laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. It's not the judiciary branch that has supremacy here, as some might have you believe. It's not an imperial presidency that has supreme authority over all things. It's not the Congress, although they have tremendous power there. The power, the supremacy, is in the Constitution. And that's why it's so important to know what it says and what it does. All of the supremacy goes back to the document itself. This living, breathing pieces of paper that define who is in power, who is in charge, what can they do, and what are we, all of us, under this power. We, the people, created this. We, the people, breathe life into it. We, the people, do this. How does this all work? Why does it work? The Constitution is supreme. The Constitution is what controls, and a lack of understanding as to what authority you have as a president, as a congressman, as a senator, as a judge, if the lack of basic understanding as to what your powers are is indefensible. If you're going to work under the system, you have to know the rules. You have to. And the rules are all laid out here in this beautiful, living, breathing document, this Constitution. It was, crafted in the 1780s, 1789, right? Go find your copy of the Constitution right now. Take a look at it. I'll wait. Go take a look. Find me where the Constitution discusses airplanes? Where does it talk about interstate railroads? Anybody? No? Trucks? Where does it talk about health and human services? Anything? How about telephones? How about cyber technology? How about privacy? Go find any of those words in this document. They don't exist. They aren't there. They're there because we, the body politic, do it. And the reason why the judicial branch has this authority, aside from the fact that it was wrested for themselves in Marbury versus Madison, is the legislature and the presidency is a temporary body. People who are elected to Congress, people who are elected to the White House are temporary occupants. They are temporary servants. The judicial branch, however, has more permanence. While these people elected to these elected bodies are the temporary will of the people, the courts ultimately are the actual solid will of the people because they aren't going anywhere. The president sitting in there in the White House now will leave at some point, and another person will take his place. Those members of Congress will resign, or they'll run for re-election and lose, or they will, for whatever reason, lose their job or move on. And new people will take their place. But these judges sit as the permanent will of the people. That's why judicial review exists. That's why when you have Article 1 giving the Congress power to create laws, they can create a law and they pass it on to the president. The president can say, I don't like it, and veto it. But the Congress can then come back and say, well, we trump your veto with our majority, with our supermajority, our 2/3. But if that law that they create, or even if the president signs on, if they create a law and the president signs on to it, the court is there to say, no, this law runs afoul of the laws of the United States. This law is unconstitutional. And they can invalidate it. And if Congress doesn't like it, or if the president doesn't like it, they can change it. They can go. If Congress doesn't like what the United States Supreme Court says about a certain law, they can draft it. They can draft a new law to fix the problem. If they don't like something that the Supreme Court does, they can change it by means of legislation. That's what we mean by checks and balances. Each branch is there to address the problems of the other. If two of the branches say one thing and the third one says no, it's out. There has to be some measure of all three of these branches coming together in order for us to work. In order for us to work, it requires that there be this unanimity of the three. And when they're not, we should not be burdened by that absence of unanimity. We should not. So that's where we are. When you hear people talk about judicial supremacy, when you hear people talk about the imperial presidency, it's not true. There is one supreme imperial authority here. It's this. This. And if you don't understand how it works, and if you don't want to adhere to it, get out. Get out. Don't, well, it doesn't apply to me. Get out. This is an essential. This is the keys to the kingdom. This right here, this is the keys to the kingdom. And if you don't play by these rules, you can't play. Simple. And it applies to Congress people, it applies to senators, it applies to the President of the United States, and every single justice that sits on the court. It applies to them all. It applies to us and everybody in between. That's the supreme authority. And if you deny its supremacy, you are denying the country itself. I would dare say that if you deny the supremacy of the United States Constitution, you are, in fact, not a patriot. You are, in fact, speaking against your country. Those people who question the authority of the Constitution are the real enemy. See that. Do that. Understand that. That's what I have for you today. As always, I'll sit tight for a little bit if there are any questions that come through. What I will offer again, and I have offered this last week, I've offered this previously. You should go about getting a copy of the Constitution on your smart device, on your smartphone. They're free. You can get them from the Apple Store. You can get them from the Android store. You can go all these places and get them. Go do that. But if you don't want to do that, if you want to be a cool kid like me and walk around with one of these things, I will give you one so you can have it. If you send me your address, I will put, well, it'll be updated. It's going to actually have the 27th Amendment in it, but that's the only thing that's different between what's here and what's there. If you want one, I will send you one. Message me. You have access to my Facebook. If you're watching this, send me a message with your address, and I will mail you a copy of the United States Constitution that you can keep in your purse, in your bag, in wherever you keep things that are important, that are life-altering, because this is. It's the rule book of our society. It is the bedrock and foundation and very spine that keeps us standing straight. This. And if you don't know what it says and what it means and what it does, you should. That's all I have for today. I went a little longer than I expected, but like I said at the beginning, the passion that I have for this document and what it means is unmatched by almost anything. And so when I see it being assaulted and threatened, that's when I feel the burn, for want of a better term, not B-E-R-N, by the way. That's when it starts to get me. And so I felt the need to come and give you a primer that you can come back to. I will post this on my Facebook wall. It'll be available to be shared down the road if you wish. I will also post this to YouTube. As I said, I have a ChrisChat channel on YouTube right now where all of these Facebook Live videos will go. You can share it from there. By all means, spread the love. Subscribers to the YouTube channel, I think I get a cute little picture and I get to choose my own URL if I get up to 100. So by all means, spread the notice and spread the love on that. But as always, the goal here is education. Knowledge is the true power in this country, and knowledge of how our government works and what our government bodies are supposed to do and the rules to which they should adhere are essential. And that's the idea here in all of our ChrisChats. Seeing no further business, I adjourn for the day. My name is Chris DiOrio, and this is ChrisChat.